Hello, this is Matt on the Moon Family Sedan channel. As most of you have heard by now, we got some not so hot news in the LBRY case yesterday. Again, it's completely over. So technically, LBRY lost this past November, but then we got to the remedies portion. There were hearings on that in January. Attorney Deaton attended, and yesterday we got the ruling. And the judge didn't quite do what he promised to. I made a whole video about it yesterday, so I don't want to do a whole lot of rehashing of that. But suffice it to say, a bit disappointed, and I'm not the only one. Because he literally stated in this ruling, with all the penalties, that he's not taking a stance as to secondary market transactions, which is outside the scope of what he effectively promised in January. So that was disappointing. But Attorney Deaton ends up highlighting a missed opportunity on the LBRY front. And also, there's this headline from the Crypto Basic. Top expert predicts Judge Torres to conclude XRP sold on exchanges aren't securities. So, this particular individual, and if I had to guess, I'd say this individual's right. We'll see what happens. Nobody knows. It's my for fun guess. But I think that we're going to have a very different conclusion in the Ripple case for a ton of reasons. I don't think we're going to have this same terrible development occur. I think that there's going to be sufficient and positive clarity for XRP on secondary markets and exchanges. Before going further, though, I do want to be clear, I do not have a legal or financial background of any kind. I'm not offering legal or financial advice, and you definitely should not buy or sell anything because of anything I say or write. I'm just an enthusiast who enjoys making YouTube videos about crypto-related topics, but just as a hobby and just for fun. All right, so there's an attorney named Bill Hughes, and he's an attorney at Consensus, and he shared this snippet from the ruling yesterday, which reads as follows. So this is from the judge in the LBRY case. LBRY also made a cursory argument presented for the first time in its supplemental brief in support of the motion to limit remedies that the major questions doctrine forecloses the SEC's efforts to regulate digital assets. And so I'll pause to note, just a quick reminder here, and this is a big ruling having to do with the EPA came down last year. Major questions doctrine, in a nutshell, states that if you are a government agency and you're going to do something that would affect the economy, so on and so forth, in a major way, if you're going to do that and you're a government agency, you must cite where you have congressional authority. And obviously, with this jurisdictional land grab with the SEC, they can't cite that because they don't have the authority to do the things that they're doing. The SEC absolutely does not. And so LBRY judge here, Barbadoro, he's noting that the major questions doctrine ultimately was brought up, but he wasn't considering it. So check this out. The judge then wrote, "This 11th hour argument has been forfeited. Collecting cases for the proposition that arguments not raised in a moving party's opening brief are deemed waived. Indeed, an argument challenging the SEC's authority to bring this enforcement action should have been raised earlier in the case, especially since the cited Supreme Court case was decided before I held oral argument on the cross motions for summary judgment." So that's why it's pretty much a missed opportunity, as highlighted here by Attorney Bill Hughes. Attorney Hughes wrote, "Oof, LBRY might be thinking it missed a real important argument. Don't be too rough with your counsel for missing this opportunity. It's fashionable now, but wasn't so at the time. Plus, not having the time and space to give the issue the proper treatment might have turned out real bad for everyone, with the judge finding the other way, which seems like a real possibility given the other merit findings." And fair enough, but, as pertains to the major questions doctrine, that sounds like something that's got real teeth. I've read enough perspective from enough attorneys to be persuaded that is indeed the case. So, yeah, unfortunately, in the LBRY case, it does look like a missed opportunity. So Attorney Hughes here is being nice and saying, don't be too hard on your counsel. Like, that sucks. And Attorney Deaton retweeted that, and here's what John had to say. "No one wants to Monday morning quarterback, and I won't do so regarding the major questions doctrine, because, as Bill states, it wasn't as fashionable as it is today. However, I believe it was a mistake to concede the first two factors of the Howey test and only contest the third prong." And I'll pause and note, that's always something that's struck me as just confusing. Why would you not go in guns a-blazing arguing on all the legal fronts that you possibly can? Why would you cede any ground? It's not like you tell me you couldn't think up a way to argue that when it comes to the first and second prong of the Howey test, investment of money, expectation of profits, you couldn't have come up with any sort of reason that perhaps the Howey test is not being satisfied. That seems like, now that's a major mistake. That's a much more major mistake in my opinion. But anyway, then John says, the LBRY user utilizes the LBC token to access the platform and heighten one's content, thus growing one's channel. The majority of token holders never viewed LBC as an investment. Also, the SEC isn't always great at providing horizontal or common vertical commonality. The SEC often conflates a common interest or an alignment of interests with common enterprise. They are not the same. The SEC is so uncomfortable with the common enterprise factor that it has disavowed it as being a part of the Howey test. See footnote 10 in the SEC's 2019 framework, where the SEC says the commission doesn't consider common enterprise as being part of an investment contract. Now, folks, you're going to love this. I highlighted this on my channel once, maybe twice ever. And if you haven't heard this, it's going to blow your mind. It definitely blew my simple little Moon Family sedan mind. Because what the SEC is doing here, and they just come right out and say it. They're like, yeah, I know, 1946 Supreme Court case, that's where the Howey test came from. Yeah, we're just not going to apply it. We're just not going to do it. We're not going to do it because we're little baby back biatras and we do what we want. Freaking asshats. Look at footnote number 10. This is what Attorney Deaton is talking about right here. They come right out and say it. Yeah, we're just not going to adhere to case precedent, binding case precedent from the Supreme Court. We're just not going to do it because we're the SEC. Anyway, footnote 10 reads as follows. In order to satisfy the common enterprise aspect of the Howey test, federal courts require that there be either horizontal commonality or vertical commonality. So pause and note. They're already saying this is required in court. They're ceding that point. But check this out. They then write, discussing horizontal commonality as the tying of each individual investor's fortunes to the fortunes of the other investors by the pooling of assets, usually combined with the prorated distribution of profits and two variants of vertical commonality which focus on the relationship between the promoter and the body of investors. So check this out. But then they write, the commission, on the other hand, does not require vertical or horizontal commonality per se, nor does it view a common enterprise as a distinct element of the term investment contract. Those little bitches just threw out an entire prong of the Howey test because reasons, as usual. Can you believe this is real life? This is ridiculous. So as far as the outcome here in the SEC v. Ripple case, there's reason to be optimistic. So there's a perspective shared within this article from the Crypto Basic. Top expert predicts Judge Torres to conclude XRP sold on exchanges, XRP on exchanges, not securities, right? So here's the tweet, and this comes from Ashley Prosper, who wrote the following. The way I see it, and then it's mapped out so you can see perspective as though an SEC expert is saying it, and then as though a response is coming directly from Judge Torres, which is not what this is, just to be clear. It's just saying this is what would be said. So, SEC expert. When XRP holders bought XRP, they were relying on Ripple's efforts to increase the XRP price. Judge Torres. You can't tell me what XRP holders were thinking when you didn't speak to any of them. Plus, you admit that if you had, it may have changed your report. Besides, I have about 3,000 affidavits from actual XRP holders that contradict your conclusion. If that wasn't enough, I have about 15 Amici briefs, several of which prove that at least some XRP holders of the XRP token were, in fact, using it and not just speculating on price. Furthermore, the SEC has failed to produce a single investment contract between Ripple and these XRP holders. Accordingly, at least one of the prongs from the Howey test has not been met. Thus, XRP sold on the secondary market does not constitute the sale of a security. The end. And so I'll just pause and note here. Obviously, that's true. At least one. I don't see how they're set. I mean, investment of money even. You're going to tell me that Tap Jets and Spin the Bits, that's with those platforms, that's an investment of money? No, it's for utility purposes, plain and simple. That's very obvious. And so this is very different than the LBRY case. And then Ashley Prosper writes, I can't see how Judge Torres concludes that secondary sales of XRP are securities, not with all the above weighing on her. Yeah, and I totally agree with that, by the way. And this is the reason, if I have to bet, does she address secondary market transactions or not. I admit I could be wrong. It's a for fun guess. I'm going to say yes. I'm going to say yes because the SEC created the embodiment theory. I don't see how Judge Torres can in good conscience not address that. I just don't see. That should be crucial to her decision-making process. But we'll see what happens. I'm not a financial advisor. You should not buy or sell anything because if anything I say are right, that would be a very, very, very bad idea. Until next time, to the Moon Family Sedan.